Today we're going to spend some time talking about very pragmatic issues that arise on a daily basis in cases involving delinquency and dependency. I am a law school teacher at Nova Southeastern University in Fort Lauderdale, Florida. I am also a NETA teacher and have been for the better part of 25 years. I run the Florida Deposition Program, and I teach in NETA programs all over the United States, including specifically programs that are directed toward lawyers who represent parties in child-type cases, delinquency and dependency. I've divided the discussion into issues related to trial skills, issues that come up in trial, and some evidentiary issues. I'm talking about issues that come up on a daily basis. While I'm a law school professor, I'm also a practitioner. I haven't been in court since Monday of this week, in fact, when I was in a matter in Miami. So let's talk about the issues. The first one that I see coming up and which I've dealt with, and I suspect a lot of you deal with, is when the judge says, we don't need opening statements. Well, we do need opening statements. The judge has a busy schedule. She has orders to sign, a long docket. How do we get the judge to listen to us and why? And the suggestion here is to ask the judge for 3 minutes to do an opening. And in that 3 minutes, you tell the judge what the key issues or key facts are in the case. Because the judge will remember that. This is a matter of recency and primacy. That judge will hold on to that piece of information. And what I suspect you will find experientially is that at the end of that case, the judge will focus on the 3 issues or the couple of issues that you present in your opening statement. All right, here's another one. This is the issue that one hears all the time. But we don't do it that way in this courtroom. We have a system that we use, and everybody uses it. Of course, nobody knows why we use it. It's a matter of what I call folklore, which is F-O-L-K-L-A-W. It's just, it was done that way, and we do it that way. In Los Angeles, the lawyers who prepare cases involving kids call it the writ of down the hall. Well, that's the way they do it down the hall. So how do we solve that problem? And here's the suggestion. Your Honor, may I please proceed in this manner? I want to be as professional as possible. I want to be as clear and concise and technical as possible. So simply ask the court for permission to do it the right way. Because indeed there is a right way. And the problem is that in very busy courts, delinquency and dependency cases, the reality is that we get sloppy in order to move forward. And so the answer is to simply ask the judge to allow me to do it what we know to be the right way. All right, let's move on to another thing. When we try these cases, they are often fact-intensive. Perhaps a bit more so on the dependency side than on the delinquency side. But even there, we may have a fact pattern that involves multiple respondents. We may have a fact pattern in which the prosecutor needs to bring a number of police officers or witnesses for the case. And so what happens is that we get immersed in a lot of facts, which I and a colleague of mine here at NETA, Mark Caldwell, call clutter. And so the suggestion here is to avoid clutter. And the reason for that is because the judge can then focus on the crucial facts. Now, unless somebody wants to, for purposes of tactics, throw a lot of information up on the wall, I suggest, and a number of us believe, that if you can focus on the 3 central factual issues in the case, you will be far more persuasive. And what that means in terms of the examination and cross-examination and use of documents is that all of your questions are focused on the key issues. All of your cross is focused on the key issues. And the documents that you put in evidence are the key documents. Dumping piles of exhibits into evidence, if you're the lawyer for the welfare department, isn't going to help the judge. So the rule is the rule of three, if you can do it. So let's move on.
Mike, another question which you touched on just at the end of your presentation came in from Paulina, and she says, you may address this, but can you briefly address Daubert and a qualifying a witness in dependency? As a parent's attorney, is the proper method to ask for a Daubert hearing if we suspect the department's witness won't qualify as an expert?
Here's a long-winded answer. Yes. Now, if you have the time and energy, it would be great to do it in writing. But if not, you make the oral application. I couldn't agree with, is it Pauline? I couldn't agree with Pauline more. If you believe that, and we know, and hopefully I'm talking to the lawyers who represent all parties, but the lawyers who represent parents, it is crucial that you carry out your responsibility in such a way that if an expert opinion is going to be offered on the basis of a standard or a syndrome or a proposition that is not accepted under the Daubert standard, that you make that challenge. So I would do it if I could in writing. If not, I would simply stand up in the courtroom and do it. It is crucial that we act as lawyers and we be assertive. Assertive in polite ways, but assertive. We are doing very complicated work in this field. I'm sorry to sort of go off on this, but we're doing very complicated work. I don't think people understand how complicated it is to prosecute a delinquency case. They think it's complicated to prosecute a capital case. Complication in dependency work and in delinquency work is huge.